Yes, Mr. Kuru.
My lord, I just observed something. My lord, the reason why the claimant had to amend his claim was the fact that the defendant has been captured by him did not exist. So it was not an issue of jurisdiction on whether the court could go on as it may. Without it sound like we would want something to go on. I would have thought that all the documents he has tendered while the court did not have jurisdiction, my lord, should be readopted. I'm not asking that tenders be readopted so that it is in line with the situation we now face. Because all the documents he had tendered were tendered when he had, in fact, the defendant did not exist. There was no such defendant that protected. So if he's going to tender that, if not, well, I could wait and keep my gunpowder dry.
Yes, Mr. Omar.
My lord, may I respectfully apply for the document before you so that I can return that then?
You are not retendering anything. Please, all you need to do is is your witness that's supposed to inform the court that he still rely on those documents.
As the court pleases.
They are already before the court. They have been marked as exhibits.
As the court pleases.
Yes.
Witness.
Yes, my lord.
In paragraph 1, paragraph 5, paragraph 6, paragraph 8, paragraph 9.
Counsel, don't waste my time, please.
Very well, my lord.
We don't have time.
And paragraph 13 and 14,
Mr. Omar,
of your statement on oath.
All he needs to say is that he has tendered documents. Those documents are the same document he's relying in respect of his amended defense.
Witness, are you relying on the document you earlier tendered in this your amended statement of facts?
Yes, my lord.
In your amended statement of facts.
Yes.
In your further statement of facts, made reference to 5 documents. But 4 are available. Do you intend to rely on these 4?
Yes, my lord.
Foundation were laid in the statement on truth. Foundation were laid in the statement on truth.
Yes.
My lord, we respectfully apply to tender number 1-4 of our further statement, of our list of documents in our further statement.
Yes.
On the 9th of January.
Yes.
20.
Yes.
That's 1 to 4. It's marked accordingly. Please.
On this part. Hey.
I know we are the documents. Their own photocopies. Firstly, and do not comply with 4 evidence.
Section. Yes.
But it's also
Yes.
Everything has not been complied.
Yes.
We urge the court to reject this document sought dependent.
Yes.
That is the purpose of complying with the practice direction of this court.
You said?
The purpose of complying with the practice direction of this court is to state that the original will be available. Those that need certification, depose in the statement on oath. So we have done all that in our statement on oath. That is why we said that we have complied with practice direction.
Compliance with practice direction is different from compliance with section 8.
My lord, practice direction requires that foundation for the documents are required for foundation to be laid for the late statement on oath. My lord, the witness has deposed to those facts that look, I printed so and so document from so and so gadgets, and they were working properly for the printing. That the original will be available or will not be available for inspection. We have stated in our statement on oath.
Which paragraph of did you say to them?
For example, get into paragraph.
Yes.
The fourth line from you say that they were created by me from my HP Pavilion using my HP jet printer 110, and it was printed the time working correctly, and data of signature were supplied to my device. My Lord, we have stated for each of the documents, we have stated all these facts in our statement. My Lord, if you look at paragraph 11, where it requires a document original, we say that the original copy will not be available as it is still the University of that's subject to restriction. So, my Lord, we have done certification in our statement on oath. Pray, therefore, to admit this document as marked accordingly.
I know by way of the journal. My Lord, by way of the journal. Yes, my Lord, we refer, my Lord, to section 4, subsection 4 of the evidence side. My Lord, firstly, before I go to that, my Lord, the provisions of a practice direction will not and will never supplant the provisions of an act of the National Assembly. Secondly, my Lord, section 84, subsection 4 talks about a certificate. Whatever that has been included, my Lord, by way of laying a foundation. No, my Lord, I am saying the document shouldn't go in. Because, my Lord, I am saying that the documents cannot go in, that they are computer generated, and there is no certificate. My Lord, the act is very clear. Yes, my Lord.
As the court pleases. As the court pleases.
No, my Lord. No, my Lord, outside that, what we are saying is, even what other things maybe comply with what my Lord is saying. But my Lord, there ought to be a certificate, and that certificate, please.
As the court pleases.
Oh, my Lord, let me be taken down. Yes, my Lord. I'm sorry, let me be taken down.
Silver against Dixon.
Yes,
Supreme
my Lord,
Court.
let me be taken down. Yes, man. Yes, man. No, but my Lord, let me be taken down that I objected to the tendering of that document without a certificate. My Lord, let me be taken down. as the court pleases. Yes. So, my Lord, by way of rejoinder, we rely on section 4, sub 4 of the Evidence Act. That the provisions relating to the production of the certificate cannot be taken care of in his absence. Given that the lack of certificate does not give credence to the integrity of the document, another source. Oh.
You say? With the
The second one. The second one. Record of payment. The third document is PhD certificate. And the fourth document is international passport.
This is my ruling. This deals with objection raised by counsel for the defendant to the admissibility of 4 documents sought to be tendered in evidence through CW1. The objection of counsel is on Section 84 of the Evidence Act. Having carefully perused the documents sought to be tendered in evidence and having listened attentively to the submissions of counsel for both sides on the admissibility of the document, it is right to know that compliance with the provisions of Section 84 of the Evidence Act can be in 2 ways, either by filing certificate or by oral evidence given. In the case at hand, the witness statement on oath adopted has clearly stated how the documents were printed, the working conditions of the device used in printing them. In the circumstances, I overrule the objection of counsel for the defendant on the non-admissibility of the document based on Section 84, subsection 4 of the Evidence Act. It is also pertinent to point out that this court, by the provisions of Section 12, subsection 2B of the National Industrial Code Act 2006, is permitted by law to depart from the provisions of the Evidence Act. Therefore, even if there is non-compliance with the provisions of Section 84, this court is on the right footing to depart from the provisions of evidence Section 84 and admit the said document in evidence. I also note that the claimant has complied with the provisions of the practice direction or laying foundation as to admissibility of photocopies of documents sought to be tendered in evidence. In view of all I have been saying above, I hereby admit the said document sought to be tendered in evidence as exhibit and accordingly admit them as marked in the additional list of evidence as exhibit C15, C16, C17, and C18. Yes. Yes, any cross-examination? Yes. No, you have to. It's either you take a date or when you start, you complete it. You can't come next week. It's next year. Even next year should be, I think, February. I don't have date in January. Hey, give me date. How many witnesses do you have, Mr. Oman? Okay, Mr. Kuri. How many witnesses do you have? Hey, please come with the witness at the next agenda. After cross-examination, he will enter witness box. This case is hereby adjourned to 6th of February 2025 for cross-examination and defense. Appearance. Yes. Hey, you have to wait until I ask you, please, counsel. I'm recording his appearance. Yes. Yes, this is the judgment of the court. On 3rd of December 2021, the claimant took out a general form of complaint accompanied by a statement of facts, witness statement on oath, list of witnesses, list of documents to be relied on, and photocopies of documents to be relied on, wherein the claimant by the paragraph 25 of the statement of facts claim as follows: a declaration that the purported termination or dismissal of the claimant's employment by the defendant on 2nd day of March 2021 is illegal, wrongful, unlawful, and unconstitutional, and therefore null and void and of no effect. 2, a declaration that the termination or dismissal of the claimant's employment on ground of theft carries with it stigma on the character of the claimant, which entitle him to substantial damages. 3, the sum of 1,003,000 naira being his payoff from 2004 to 2020. 4, the sum of 1 million naira as against the defendant as general damages. 5, the sum of 1 million naira against the defendant for cost of litigation. And 6, 10% interest on the judgment sum from the date of judgment until entire judgment sum is fully liquidated. Following failed effort by the bailiff to serve the defendant with the originating summons commencing this suit, the defendant was served through substituted means as per order of this court made on the 25th day of May 2022. Upon being served with the originating processes commencing this suit, the defendant on the 24th day of May 2022 filed a statement of defense wherein the claim of the claimant was denied. On the 6th day of December 2022, the claimant testified as CW1 in proof of his case. The claimant, after identifying his witness statement on oath, adopted it as his evidence in this case. 6 documents were tendered in evidence through CW1. They were admitted in evidence and marked as Exhibit C1 to C6. The case of the claimant, well, due to time, I will skip reading all the preliminaries. I will skip reading the case of the claimant, the case of the defendant, the submissions of the defendant, the submissions of the claimants. I will go straight to the decision of the court. I have considered the processes filed by the parties in this suit, the evidence laid in the course of trial, and written and oral submissions of counsel for both parties. The claimant in this case is seeking for 6 reliefs. The first and second reliefs are for declaration, while the remaining reliefs are for special damages, general damages, cost of litigation, and interest on the judgment sum. Coming to the determination of the claim before the court, it has been established by a long line of decided cases that the burden of proof in civil cases lies with the claimant or the person who asserted. Therefore, the burden is on the claimant in the instant case to prove he's entitled to the relief sought before the court. It is when the claimant has adduced sufficient, cogent, credible, and admissible evidence establishing his claim that the burden shifts to the defendant. This is because the burden of proof in civil cases or matters is not static and may shift in the course of proceeding in a case, depending on the state of pleading at various stages. The initial evidential burden of introducing evidence to prove claim of a legal right or liability based on the assertions of part made upon which right and liability is claimed is placed on the claimant squarely on the shoulders of the claimant, and until it is satisfactorily discharged on balance of probabilities or preponderance of evidence as required under Section 134 of the Evidence Act, it does not shift person to Section 133 of the Evidence Act. In this case, the claimant is the one that desired this court to enter judgment in his favor as per his claims. Therefore, the claimant bore the initial evidential burden of proving the facts asserted. See the case of Adegoke versus Adibi and host of other cases cited therein. On the declaration being sought, the law is right that claimant seeking for declaratory relief must succeed on the strength of his case. The evidence to support a claim for declaration can be oral or documentary. The court would not make declarations or grant declaratory reliefs unless such reliefs have been proven by evidence of the parties seeking for such relief, regardless of whether or not the party on the other side filed evidence or not. Grant or refusal of declaration is discretionary. It is granted only in the circumstances in which the court is of the opinion that the party seeking it is, when all the facts are taken into consideration, fully entitled to the exercise of the court discretion in his paper. See Alao versus Akano, CNNPC versus Iwari, CCPC versus INEC. There is no doubt from the pleadings and evidence contained in the written statement on oath adopted by the claimant as his evidence that in the course of performing his duty, he made a mistake in the counting of iron rod for loading into the trucks of the defendant's customer. According to him, he directed the crane operator to remove the excess iron rod and keep them aside at a particular place where spoiled iron rods or over-counted irons are kept. According to the claimant, one of the defendant's official by name Mr. Fall, a Chinese national, on citing the excess iron, inquired why the excess iron were kept in that place, and he explained to him. It is also the case of the claimant that after normal counting and cross-checking, the excess iron will be returned back to the finishing section where the counting was carried out. But on that day, the reverse was the case, as Mr. Paul invited the claimant to his office and told him that for his mistake, the sum of 20,000 naira will be deducted from his salary. The claimant accepted, and the said sum was deducted from his February 2021 salary, and which was paid in March 2021. The claimant was photographed and his picture posted at strategic location within and outside the dependent premises and EPZ, which with inscription notice of dismissal and ban for entering the dependent premises. According to the claimant, when he was dismissed and banned from entering the premises of the dependent, that was when he knew for the first time that through the notice of dismissal and ban that he was alleged to have been caught adding extra pieces of iron rod to truck being added in the factory, and also that it was discovered that up to 30 pieces of extra iron rods are being added every time any truck was being loaded. The claimant, apart from his oral testimony, did not call the crane operator he directed to set aside the iron rod in line with the practice of the defendant. He did not also tell the court whose duty it is to return the excess iron rod to his finishing section of the dependent. This has left a vacuum in the evidence of the claimant. The defendant, in reaction to the claim of the claimant on the iron rods and deduction of 20,000 naira from claimant's salary, stated that One Alex Emmanuel, a staff of the security department of the dependent, observes that the claimant has deliberately added 30 pieces of iron rod to be loaded to a truck of one dependent customer. The claimant was reported to the chief security officer and DW1. The chief security officer and DW1 confirmed the allegation and confronted the claimant and threatened to report the matter to the police. However, the claimant admitted his misconduct and confessed to placing 30,000 iron to a customer that has already left. The matter was also reported to Mr. Paul, the supervisor of the section, who went and confronted the claimant. He confessed to the misconduct. The sum of 20,000 deducted from claimant's salary was for 30 pieces of iron rod. The claimant confessed to have placed in a truck of one of the dependent customers who had already left the factory. The claimant was paid balance of his entitlement and was escorted out of the premises. And was escorted out of the premises of the dependent by the security men. His photograph was pasted for those not on duty, so that when they come, they would know that claimant had been dismissed and is not allowed to enter the premises of the dependent. It is clear from the pleadings and evidence before the court that the claimant seems to be saying that the 20,000 he agreed to be deducted from his salary was for mistake he committed in the counting of iron rod, which he ordered the crane operator to keep where spoiled and over-counted iron rod are kept. While the defendant is saying that the 20,000 was for 30 pieces of iron rod, the claimant confessed to have placed in a truck of one of the defendant's customers. I'm inclined to agree with the defendant that the sum of 20,000 deducted from claimant's salary was for the 30 iron rod placed by the claimant in one of the dependent customers' truck. I came to this conclusion in view of the assertion. This assertion was made in the statement of defense by the defendant, and the claimant failed and neglected to file a reply to the said assertion to controvert or contradict it. This means claimant has accepted the assertion to be true and correct. The law is right. What was admitted need no response. Secondly, I do not agree that a worker who has worked hard to earn his salary will, in his right senses, agree to deduction of the sum of 20,000 from his hard-earned salary without protest. If it is true, as the claimant has stated, that there is a place where spoiled and overcounted iron rods are kept, then the claimant would not have allowed the defendant to surcharge him for making mistake, as doing so will be against even the policy of the defendant. From the evidence before the court, the claimant's dismissal termination from service was as a result of misconduct in the alleged placing of loading of iron rod into the defendant's customer's truck. The claimant is also alluding issue of being all that the employee is required to do is to ensure fair hearing is accorded to the employee. See Arinze versus First Bank of Nigeria, see also ZD versus River State Civil Service Commission. What is required of an employer before summarily dismissing an employee in cases of misconduct bordering on criminality is to satisfy the rules of natural justice and fair hearing. A person likely to be affected directly by disciplinary proceeding must be given adequate notice of the allegation level against him to afford him opportunity for representation in his own defense. The complaint against him must not necessarily be drafted in a form of a formal charge. It is sufficient if the complaint as formulated conveyed to him the nature of the accusation against him. It is not necessary, nor is it a requirement under the law, that before an employer summarily dismisses his employee from his services, under the common law, the employee must be tried before a court of law where the accusation against the employee is of gross misconduct involving dishonesty bordering on criminality. See Arinze versus First Bank, Sufra. In the case at hand, the evidence showed that the incident that led to the termination or dismissal of the claimant took place on the second day of March 2021. A careful perusal of paragraphs 11, 12, 13, and 14 of the claimant's statement of facts clearly goes to show that the claimant was not given fair hearing in the procedure adopted in terminating or dismissal to terminate or dismiss him from service. This may have also been the reason why no letter of termination or dismissal was issued to the claimant. Apart from Exhibit C3, which is unsigned, not meant for the claimant, but meant for the general public, the defendant in her response stated that the claimant's photograph was to evidence that claimant had been paid his entitlement and he had been dismissed, was no longer entitled to enter the defendant's premises, especially for information of security who were not on duty at the time the claimant was dismissed from defendant's employment. The banning of claimant from premises of the defendant was attributed to his admission of misconduct. The defendant also denied the claimant the claimant was threatened with soldiers. The way and manner the defendant treated the case of the claimant clearly shows that the claimant was not accorded fair hearing, as no query was issued to him or disciplinary committee set up to try him for misconduct. All that was done was claimant's misconduct was reported to one Mr. Ford, the supervisor of the section, who it was alleged confronted him, and when he confessed for misconduct and agreed that the sum of 20,000 naira should be deducted from his entitlement in lieu of notice from his entitlement in lieu of the iron rods he confessed selling to the dependent customer previously. Thereafter, the claimant was paid his balance of his salary and escorted outside the defendant factory by the defendant's security men. See paragraphs 4, 5, 6, and 7 of the defendant's statement of defense. A careful perusal of these abaments will reveal that the claimant was not accorded fair hearing in the whole process leading to his termination or dismissal. In the circumstances, the defendant having not accorded the claimant right to fair hearing, his termination dismissal from service was wrongful, as it was not done in line with the law. It is to be noted that to accord fair hearing is to give the person entitled to the opportunity of knowing the allegation level against him and give him adequate time to defend himself. In the case at hand, the process that led to the termination dismissal of the claimant took place within few hours, as everything was done within the day of the incident. To even make matters worse and to show lack of according claimants with fair hearing, the defendant have asserted that the claimant was threatened that he will be handed over to the police and he confessed to misconduct. This has glaringly shown that claimant, if there had been any admission of misconduct, what was not voluntarily made, as he was threatened with being handed over to the police. I believe the threat had instilled some fear into the claimant. This goes to vitiate any claim of compliance with due process. In the circumstances, it cannot be said that the claimant's dismissal followed due process. The counsel for the defendant has argued that the evidence of the claimant in respect of issue of his employment and Exhibit C6 are contradictory, and that the court should reject the entire evidence of the claimant as not reliable. It is significant at this juncture to re-echo the law on documentary evidence that documentary evidence is superior to oral evidence. This is because while a witness may lie and his evidence may not be accepted, or he may have forgotten some aspect of the evidence, documents, it is said, do not lie. And once properly received in evidence, the court is bound to act upon it. In the case of FATB Limited versus Partnership Investment Company Limited, the Supreme Court, far Igu JSC as he then was, emphasized the importance of superiority of documentary evidence as follows. Documentary evidence where it is relevant ought to be produced and tendered as they speak for themselves against the ipse dixit of a witness, which may not readily be accepted by the court. See also BON Limited versus Saleh. Also section 132 subsection 1 of the Evidence Act. See also Best Bank of Nigeria's by May Clinic, and also Union Bank of Nigeria Limited versus Ozigi. In the instant case, Exhibit C1, the claimant letter of employment is by law far superior to the ipse dixit of CW1 under cross-examination or witness statement on oath. Therefore, I am unable to agree with counsel for the defendant on the issue of contradiction. It is clear the claimant asserted that he was employed on 5th day of January 2000, and he stated that he will rely on his letter of employment. The letter of employment tendered as Exhibit C1 shows that he was employed on the 5th of January 2004. I do not consider this as a contradiction, as Exhibit C1 being documentary evidence tendered by the claimant has clearly cleared any doubt concerning the date of employment, and the defendant has admitted Exhibit C1 tendered by the claimant as showing the correct date of employment. I discountenance submission of counsel for the defendant in this regarding this issue of date of employment, as the parties are at ad idem on Exhibit C1 as the letter of claimant's employment with the defendant. On Exhibit C6, there is no issue of threat mentioned therein. The claimant had, in his statement of fact, clearly asserted that he was threatened by the defendant that if he did not agree to be photographed, they will use soldiers attached to the defendant to deal with him. I do not agree with the counsel for the defendant that claimant has contradicted himself. Exhibit C6 is very clear and unambiguous, and it is only evidence to show that the letter was written and demand was made, and no more. It never proved anything. Though the claimant was not accorded fair hearing, and that he rendered, and that may have rendered his dismissal wrongful, there are other disturbing issues that will work against the success of the claim of the claimant. In the first instance, by the paragraph 15 and 16 of the statement of facts, the claimant stated that on 21st day of May 2021 at EBZ, the legal officer of EPZ, one Barrister Amaka Tony of the defendant, and himself at a meeting toward resolving the issue of his dismissal, the defendant reinstated the claimant. In the month of June 2021, the defendant reinstated the claimant and directed him via phone call to resume work, but the claimant declined the offer of the reinstatement because his good reputation has been tarnished and the working environment is now harsh and oppressive following the emergence of new management of the defendant. It is clear to me from the assertions in paragraph 15 and 16 of the statement of fact that assertions therein have watered down the claim of the claimant, in that these abatement have clearly shown that there was effort made for an amicable settlement which had yielded positive results, and the defendant had reinstated the claimant back to his work, and he was asked via telephone call to resume work, but on his own he declined and refused to resume. The action of the claimant has now shown that it is the claimant himself that repudiated the contract of service between him and the claimant, as the earlier dismissal has been of no effect, since claimant had been reinstated to continue with his job, but on his own volition decided not to resume. This means he is the one that ended the contractual relationship. This was done without giving notice or payment in lieu of notice. The contract of employment between claimant and the defendant had ended abruptly without due process. Since it was the claimant that now repudiated the contract, he is not entitled to any claim from the defendant. This has also put light to the claim by the claimant that the defendant has refused amicable settlement of the case. From all I have been saying above, the claimant has not been consistent in his claim. and having repudiated the contract between him and the defendant, he is not entitled to any relief, as the court will not allow a party to benefit from his own wrong or to speak from both sides of his mouth. The claimant is not entitled to declaration. He is seeking for the court to declare his dismissal illegal, wrongful, unlawful, or unconstitutional, and therefore null and void. The law is well settled that a party making a claim before a court of law is required to be consistent in his claim. The court will not allow a party to speak from both sides of his mouth. The court would hardly decree anything in favor of such inconsistent party before it. Indeed, consistency is one of the most important signposts or hallmark of the truth in litigation arena, and all parties are enjoined at all times to endeavor to be consistent, as it ranks a great deal on the ladder of credibility. See the case of Governor of Lagos State and others versus Oyago Nigeria Limited and another. See Fabio Boli, Abraham George Will. It is right that a party cannot be allowed to blow hot and cold at the same time, either by his pleading evidence or argument. Equity prohibit or preclude a party from approbating or reprobating or affirming a state of affairs at one time and denying same not permissible. See the case of Attorney General River State versus Attorney General of Akwa Ibom State. See also Ladega versus Durusomi. It is also a sacrosanct rule of pleading that a party must be consistent in his pleading and also be consistent with his evidence. He cannot be allowed to, for the purpose of placing a burden on the other party, to present two diametrically different positions on the same matter in his pleading and expect to have the nod or stamp of the court on his double assertion. See Odopin versus Oni, where the Supreme Court has this to say, where both parties are familiar with or the land in dispute, the question of its identity or its certainty will cease to perplex the trial court. So also the appellate court, and neither party will be allowed to place a cloak in the wheel of justice by mischievously raising the issue of identity in order to becloud what is otherwise a piece of land that is well known. Parties must be consistent. It is clear from it is settled principle of law that the foundation of an action fought on pleading is the pleadings of the parties, which set out the summary form of the material facts upon which each party intend to rely at the trial. Pleading therefore defines the limit with accuracy and clarity the real matters in controversy between the parties. It is by the pleading that parties enable to articulate and frame the issue in dispute between them, and which the court will be called upon to adjudicate. The claimant in his pleading has presented two diametrically opposing positions. The court will not allow the claimant to derive the defendant in trying to obtain a favor from the court. In the circumstances, the claimant, having not been consistent, has failed to prove anything. After all, he repudiated the contract himself. The case of the claimant lack merit, same is hereby dismissed. Yes, you are open. Yeah. Call the next case. Yes. 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 Yes.